Good morning, everyone. Welcome back to Assembly Judiciary after our glorious 8-day break. But again, that's the fruits of the labor of everyone that works so hard up here in Judiciary, our members and our staff that we were able to take 8 days off. So welcome back, 8 a.m. It's a little pinchy this morning, but I know we'll make it through. So with that, Committee Secretary, will you please take the roll?
Assembly members Cole, Dahlia, Gonzalez, Gray, Hanson, Hardy, LaRue Hatch, Marzola,
Present.
Moore,
Here.
Nadeem,
Present.
Orantlicker,
Here.
Roth, Urick, and Chair Miller.
Here. And please mark the other members, Hardy and LaRue Hatch, present as they arrive. And I'm sure you have Assemblymember Gray marked present. Okay. So with that, just a few housekeeping reminders. Please turn down your electronics so not to disturb anyone. The meeting ID for today, the phone number is 888-475-4499, and the meeting ID is 813-579-00993. And I say that for anyone wishing to participate over the telephone in order to make public comment or to testify on a bill. Again, we will have public comment at the end of today's meeting. We do have 3 bill hearings today. I ask that everyone presenting their bills please keep their presentation to 15 minutes, and anyone testifying on a bill or making public comment, please keep your comments to 2 minutes. Also, please remember that when you are testifying or making public comment, to please state your name and spell it so that we have it correct for the record. With that, also welcome to Second House. So now we are primarily hearing Senate bills. We will start today. We'll take the agenda in the order that it's written, and we will begin with with Senate Bill 30. So we'll give you a few moments, and whenever you're ready, please proceed.
Good morning, Chair Miller, Vice Chair Marzola, and all members of the Assembly Judiciary Committee. My name is Chris Tirico, and I'm the Chairman of the Board of Parole Commissioners. Along with me today in Carson City is Katie Fraker, who's the Executive Secretary of the Parole Board, as well as Justice Bell with the Nevada Supreme Court, who is present in Las Vegas. Justice Bell will be providing some additional testimony on this bill. Thank you for allowing to present SB 30 today. With that, I would like to turn the microphone over to our Executive Secretary, Katie Fraker, who will first present Section 1.7 of this bill, followed by Justice Bell, who will present the other sections.
Katie Fraker for the record, K-A-T-I-E-F-R-A-K-E-R. Good morning, Chair Miller, Vice Chair Marzola, and members of the Assembly Committee on Judiciary. My name is Katie Fraker, and I am the Executive Secretary for the Nevada Board of Parole Commissioners. The purpose of SB 30 is to require a name-based inquiry for public record requests regarding parole decisions. At times, the board will receive a large, broad public records request that will ask for copies of all grant or denial orders from the past 1 or 2 years. As the board conducts over 6,000 hearings per year, this is an extraordinary request. The board conducts hearings for all types of crime and offense severities. The board already posts the monthly parole actions and quarterly parole statistics on its website for the public to access. This bill would require the requester to supply the board with the name of the person or persons they are requesting the records of. The passage of this bill will allow staff to fulfill all public record requests in a timely manner. It will reduce the number of hours required to complete public record requests, avoid possible overtime compensation, and will ensure that the requester is acquiring the information they need. Also, this only applies to parole orders, orders granting parole, orders denying parole, and parole violation hearing orders. All other documentation in the parole file is already considered confidential pursuant to statute. In no way is this bill attempting to limit public access to records, but the only aim is to ensure that the requester is communicating and clarifying the specific records they need. Thank you.
And at this time, I'd like to turn the microphone over to Justice Bell, and we'll be available for questions afterwards. Thank you.
Good morning, Madam Chair and members of Assembly Judiciary. My name is Linda Bell, Lindabell. I'm a justice on the Nevada Supreme Court, and for the purposes of this bill, I also sit on the Nevada Board of Pardons. So by statute, when someone is being considered for a pardon, the Pardons Board has to send notice to the judge and solicit input from the judge, which creates a bit of an ethical problem. So we're asking them to provide input. At the same time, the Standing Committee on Judicial Ethics, in Advisory Opinion JE 11-008, has said that judges are not permitted to voluntarily provide opinions about cases. So if a judge responds to the solicitation that the Pardons Board sends, they're violating the ethics code. And the reason for that is because judges are supposed to remain neutral, right? We view a case, make a sentencing decision, but then we lose jurisdiction over the case. It winds its way through the system. We are allowed, if we're summoned, so if a trial court judge or sentencing judge was summoned by the Pardons Board to provide factual information, they could do so. So for example, if someone applied for a pardon and one of their bases was that the judge didn't consider a certain piece of information at sentencing, the Pardons Board could summons the judge, have the judge come in and say, yes, I considered that, or no, I didn't consider that. But what the judge can't do is come in and say, yes, that person is a great candidate or they're a poor candidate for the pardon, because that's a violation of our ethical code. So we're just trying to clean up the statute to eliminate those solicitations to the judges, so that we aren't causing problems, because it's a little bit of a trap for the unwary. We have very well-meaning judges who get an official notice and they're trying to be helpful and respond, but they're really not permitted to. And so that's the remaining changes in the statute. Thank you.
Thank you so much. And with that, I will open it up for questions, beginning with Assemblymember Roth.
Thank you, Chair, and thank you so much for the presentation. I think this question is for the chairman. And so I just want to make sure, going through the bill, it looks like we're taking some consideration of a district court judge's sentencing decision out of a decision for granting parole. And so can you explain, I know there was previous testimony on AB 91 that there was concern around removing judges from that process of relooking at sentences. So can you explain why this is different and more appropriate?
Chris DeRico for the record. So I believe what you're referring to here is actually with regards to the Pardons Board portion of the bill and Justice Bell. Section 1.7 directly references the parole board, so I would defer to Justice Bell on that.
This is Linda Bell for the record. I'm not sure I understand the question. So ethically, judges aren't.
And just to clarify the
permitted.
question, I'm sorry, Justice. Sure. I'm just going to step
okay.
in. Yeah, sorry. Just to clarify this question is for you, Chairman, because what we're looking at is there's two ways to relook at a few ways to relook at a sentence. We can, an individual could be granted parole or potentially have that sentence relooked at, or they can seek a pardon. And so in this bill, we're looking at removing judges from being able to provide input on a pardon, but why is that different than allowing judges to not have a say on parole?
Chris DeRico for the record. So this portion of the bill that you're referring to, I just for clarification, Section 1 and Section 1.3. Is that correct? Okay, so that portion of the bill here was brought about as an amendment along with and in support with the Supreme Court and Justice Bell because of their ethical standards. Now, it has nothing to do with the parole portion, so I can't comment as to why the ethical standards and the portions of that amended part, which is now part of this bill. I can't comment on that.
This is Justice Bell. I think I can speak to the question. I'm sorry, Assemblywoman Roth, I understand better now. So I actually think it's a problem for parole too, but I'm not familiar with what you're speaking about. Because I'm on the pardons board, this bill has directly only to do with the pardons process, which comes well after, somebody gets sentenced, they go to prison, they go in front of the parole board, and that's an option. If they do not receive parole or they have a sentence that doesn't permit parole, there is an option to go to the pardons board. I think the ethical problem is the same unless the pardons or parole board has summoned someone to come in front of them, a judge to come in front of them. We're not ethically permitted to provide that kind of information. I mean, we're not ethically permitted to give an opinion. We can, if we're summoned, go in front of the board and provide factual information.
Thank you. Could you reference that judicial review again? You said it came out of the ethical.
I'm sorry, I thought we had provided a copy. I know we did to the Senate. It's the Standing Committee on Judicial Ethics, and it's advisory opinion JE 11-008. So what it says is the committee believes that unless duly summoned, it is not appropriate for a judge to voluntarily provide written comments to a parole board regarding the release of a prisoner on a matter which, this says which the judge did not preside, but in the event of a pardons board, it would be, because it's an act of grace, then it's just the judge cannot give an opinion about the pardon.
All right, thank you so much. We have a question from Assemblymember Cole.
There we go. Thank you for the presentation. My question is of technical nature. You mentioned if a judge is summoned. The language in the bill says subpoena. Is that the same thing, or can a summons be in a different format? Thank you.
It's the same thing. This is Justice Linda Bow for the record. It's the same thing.
All right, thank you. Not seeing any additional questions, I will go ahead and open it up for testimony, beginning here in Carson City for testimony in support of Senate Bill 30. Anyone wishing to approach? Not seeing anyone. Is there anyone there in Carson City that would like to testify in Las Vegas that would like to testify in support? Also not seeing anyone. Broadcasting, will you please open the lines?
Chair, the public line is open and working. There are no callers to testify in support at this time.
Okay, thank you. Then I will open it up for testimony in opposition. Is there anyone here in Carson City wishing to oppose Senate Bill 30? Not seeing anyone, and I don't see anyone there in Las Vegas. Broadcasting, will you please open the lines?
Chair, the public line is open and working. There are no callers at this time.
Thank you. Then I will open it up for neutral testimony, beginning here in Carson City. Not seeing anyone, and there's no one in Las Vegas to testify. Broadcasting, will you open the lines?
Chair, the public line is open and working. There are no callers at this time.
Thank you so much. Then I will, okay, the bill sponsors have, Judge Bell, do you have any final remarks?
No, Madam Chair. Thank you so much to everybody for your attention to this.
Okay, thank you. Then I will go ahead and close the hearing on Senate Bill 30. Next, I will open the hearing on Senate Bill 13. Should also, Senate Bill 13 revises provisions relating to the disposition of bail. Mr. McCormick, when you're ready, please proceed.
Thank you, Chair. Good morning. My name is John McCormick. Last name is McCormick, Assistant Court Administrator at the Nevada Supreme Court Administrative Office of the Courts. Senate Bill 13 is designed to, or intends to put a provision into statute that will allow the defense and prosecution to stipulate to a disposition of bail other than exoneration. And basically what this does is facilitate negotiations for facilitate case negotiations, because currently, as we proceed through the statute with bail, there's a disposition, but it does not provide a statutory authority for stipulation, and that is what we're seeking to add here. Basically, what it does is mean, to give you an example, is, excuse me, a defendant and the prosecution come up with a plea deal, they negotiate. The defendant has has paid bail in the process of the case. This will allow that bail, rather than being refunded or exonerated pursuant to statute, they can stipulate to another use. And generally what that means is they can stipulate to use the bail to satisfy a restitution amount. And so this is providing statutory authority for that practice. There is some case law that says that statutory authority is necessary, and so that's the purpose of this bill.
Ready for questions? All right. There doesn't seem to be any questions. All right, so let's do this. Let's go for the world's shortest bill hearing. Anyone here in Carson City wishing to testify in support of Senate Bill 13? Not seeing anyone, not seeing anyone in Las Vegas. Broadcasting, will you open the lines, please?
Chair, the public line is open and working. There are no callers at this time.
Thank you. Is there anyone here in Carson City wishing to testify in opposition of Senate Bill 13? Not seeing anyone, and there's no one in Las Vegas. Broadcasting, please open the lines.
The public line is open and working. There are no other callers at this time.
Thank you. I will open it up for neutral testimony. Is there anyone here in Carson City wishing to testify in neutral? Not seeing anyone, and there's no one in Las Vegas. Broadcasting, will you open the lines?
Chair, the public lines are open and working. There are no callers at this time.
Thank you. That was neutral, right? All right. I'm like Flash Gordon up here. I'm so quick. Okay, so Ms. McCormick, do you have any final remarks you'd like to make? All right, thank you. With that, I will go ahead and close the hearing on Senate Bill 13. And I'll have to go back to the minutes to see the time. That may be the record for the world's shortest bill hearing. So thank you. So the hearing for Senate Bill 13 is closed. I will now open up the hearing for Senate Bill 17. Welcome back to this committee room, Your Honor. With that, the Senate bill hearing is open, so whenever you are ready, go ahead and introduce yourselves and you may proceed.
Good morning, Chair Miller and members of the committee. My name is Kendra Birchie, B-E-R-T-S-C-H-Y, and I am a Justice of the Peace in Reno, Nevada, Reno Justice Court. Senate Bill 17 introduces targeted small improvements to our existing specialty court statutes, creating a significant and positive impact on the lives of our citizens. Specialty courts are therapeutic programs that use evidence-based practices, treatment, and case management to address the root causes of criminal behavior, including substance use and mental health disorders. Currently across Nevada, there are approximately 64 therapeutic courts. These courts range from focusing on mental health, substance use, veterans issues, developmental disabilities, women in need, youthful offenders, among other focuses. Based on these extensive research that has been undertaken across the nation, therapeutic courts are considered the most effective justice intervention for individuals who have substance use or mental health disorders. Through collaboration with treatment providers, law enforcement, intensive supervision, prosecution, defense, and the judiciary, these courts operate to provide continuous individualized support to programs that promote lasting change. These programs are saving time, resources, and money by diverting appropriate cases early in the criminal justice process and redeploying prosecutorial and other resources towards the most serious and complex cases. So basically what these therapeutic courts do is they help save lives. They help save individuals to ensure that they do not come back before the court. They save taxpayers money, and more importantly, they have been proven to reduce recidivism, meaning that it is less likely that someone who participates, even if they don't successfully complete one of these courts, they are less likely to return back into the criminal justice system. I know that Mr. McCormick spent a lot of time in front of this committee really discussing all of the positive data that we have here in Nevada about how these courts improve our lives of our citizens. So I'll turn then to the bill specifically of what therapeutic courts do is you can enter into those courts in 3 different types. You can enter it as a pre-prosecution diversion, you can enter it as a condition of probation, or as a diversionary basis. And I'll turn first to Section 2 and the remaining sections of this bill. All that these sections do is allow for an individual who's been accused of a misdemeanor to have the benefit of a diversion, so having it as if the conviction, they didn't enter a plea or have the conviction taken off of their record. We currently allow for that to occur for felony and gross misdemeanor cases, so all that those sections do is indicate that if somebody is in a misdemeanor court, so for a lower level offense, they get that same benefit if they complete a therapeutic court program. Section 1 is regarding our pre-prosecution diversion statutes. So pre-prosecution currently exists in law, and I want to make sure it's very clear, is that this is only for misdemeanor offenses. So if somebody has been charged with a felony or a gross misdemeanor offense, they are not eligible under our current law. What this bill proposes is not to change that portion. So this only applies for individuals who are accused of those lower level or misdemeanor offenses. The goal in Section 1 with the amendments is to increase the ability to allow individuals to ask for those pre-prosecution diversions program. The current law is very restrictive, so if anyone has a prior conviction, even if it's for a misdemeanor disturbing the peace, they're not eligible for a pre-prosecution diversion program. This simply allows for additional individuals who can ask for that ability. The amendments that we have created in Section 1 are based largely off of conversations that were had with stakeholders in order to address some of their concerns about expanding this pre-prosecution diversion too far and allow for too many individuals to be able to ask for it. So those amendments were based off of conversations with stakeholders. I also just want to make sure it's very clear of that for any therapeutic courts that are to be initiated through any of these statutes, those courts, the best practices are to work with counties, work with the different stakeholders before starting that program. And I'll turn to Mr. McCormick for him to provide just some additional information for the record regarding those conversations.
Thank you, John McCormick for the record, last name McCormick. As Judge Birchie indicated, we did work extensively on this amendment with both with the district attorney's office. And as it exists, it expands the program, but not to offenders or individuals who are accused of violation of protection order, domestic battery, DUI. There's a number of them in that section that I could go through. So it expands the program, but still keeps violent offenders and those offenses that people were concerned about from asking for that pre-prosecution diversion program. And additionally, as we were discussing this bill in the other house, there was a concern from some of the counties on the point that Judge Birchie mentioned there at the end, that some courts want to start programs without talking to their funding body first. And while that is not while that doesn't necessarily fit in the scope of the statutory language in this bill, we are working to update our specialty court funding guidelines, which is what we follow at the AOC to give out the specialty court money, to require that a new program has to affirmatively engage with their county before applying for or receiving our funds in order to encourage that increased collaboration. And then there's one other section of the bill I would just like to point out, or one other portion of the bill I would like to point out briefly. It is in Section 3, and it allows a court to provisionally refer a defendant to the court so we can make sure they get the correct and proper assessments and evaluations. Currently, that's a gap because we have a person who may need to go to specialty court or may be appropriate for that program, but there's no mechanism to get them the appropriate evaluation to make sure that that's what we're doing. So this allows a provisional referral so the court can use its existing infrastructure to effectuate that evaluation to make sure we're putting the defendant into the correct program.
Kendra Birchie for the record. Just to add on that, in our courts, so for misdemeanor level courts, it's the court who pays for a lot of those evaluations. And so this portion is necessary in order to ensure that we can use our existing therapeutic court funds to pay for those evaluations. Thank you.
Thank you. And are you ready for questions? Okay, thank you. So our first question comes from Assemblymember LaRue Hatch.
Thank you, Chair, and thank you for presenting this morning. So my question is on the amendment. I'm looking at the very bottom of page 1 where it says, has not previously been convicted of or determined to have committed. And I just wondered if you could explain the difference between those and why we're adding in that second phrase.
Thank you, John McCormick for the record. The reason we're adding that is basically it's sort of a technical legal thing. Have they been convicted or determined to? So maybe if they offered an Alford plea or pled no contest, so they were determined to, but they didn't admit. So it is a sort of a technical bit of language.
Thank you. Our next question is from Assemblymember Roth.
Thank you, Chair. Thank you so much for the presentation. I was just looking at the original bill as compared to the first reprint, and it looks like the list of offenses that would preclude someone from pre-prosecution diversion has gotten a lot longer. So can you walk through why that is, especially when someone would only be granted pre-prosecution diversion with input from a district attorney and a defense attorney, and so it seems like it really limits how a judge can actually holistically look at what an offense might be.
Thank you, John McCormick for the record. As you indicated, Assemblymember Roth, we did initially have this a lot more broad, but in the discussions with stakeholders, these were sort of the issues that they brought up as being, the red lines, the offenses that they felt it was not appropriate for the defendant to be able to ask for that program based on the nature of the offense. So that was the list became bigger upon those discussions to make sure that we were collaborating appropriately.
Thank you. And just for clarification, so under current existing law, is someone eligible for pre-prosecution diversion under this excluded list? And would this law now take them out of that, remove that ability?
Thank you, John McCormick for the record. Currently, as the statute exists, the only people eligible for pre-prosecution are persons who have no criminal convictions in this state aside from minor traffic offenses. So this does expand it, but excludes certain categories of offenders. So it opens it up more, but doesn't open it up necessarily as broadly as the initial draft had.
Thank you. Our next question is from Assemblymember Ordenlicker.
Thank you, Chair, and thank you for bringing the bill. So I'd like to follow up on some my colleagues' questions. So, as you indicated, that the proposed list was broader, and then stakeholders came in, and they might have come in and said, data from other states show that this is too risky a class to do diversion. Or they may have come in and said, these are especially problematic crimes and they don't deserve this kind of special treatment. Or they may have given other reasons. Could you elaborate on the reasons they gave, where their reasons fell in the range of different reasons?
Thank you, John McCormick, for the record. The concern was, and I will go through section 1 a little bit here to help answer that, was particularly from the district attorney's perspective, is they wanted to make sure that violent offenders, as defined in 200.408, were not permitted in, people who've, with a conviction for domestic battery, stalking, harassment, coercion, violation of protection orders. So their thought was those are sort of more intense level crimes, that they're violent, they're victimizing, and that, like domestic battery is not the same as public disturbance, for example, in terms of seriousness and impact to the community. And so the desire was to make sure that we were offering appropriate offenders, I believe, the chance for this diversionary program, but not people who have engaged in those engaged in conduct that I think collectively there is greater societal scrutiny or greater societal harm that stems from it.
Thank you for that. Was there, to follow up on my colleague's question, was there any consideration for those offenses or convictions that have higher or lower recidivism rates? Was that any part of the consideration?
Thank you, John McCormick, for the record. The recidivism rates did not necessarily come up in the discussion. It was more of an offense-based focus on the feeling that these offenses were more egregious than, say, other misdemeanors.
Okay, thank you. I don't see any additional questions at this time. So with that, we'll go ahead and open it up for testimony. Anyone here in Carson City wishing to testify in support of Senate Bill 17? Wait, is this our first testimony of the morning? It is. Please proceed.
Thank you, Chair, members of the committee. It's nice to be back. Harrison Epstein, for the record, Harrison Epstein. I'm a legal extern with the Clark County Public Defender's Office. Criminal records can have lifelong consequences. Pre-prosecution diversion programs are smart on crime, evidence-driven approaches that reduce recidivism and help people break the cycle of incarceration. The more people are eligible for these programs, the safer our community will be. We support this bill because it is still a step forward. However, the original bill was even better, and we do wish that we didn't see it limited in this way. Thank you all.
Right. Is there anyone else wishing to testify according to the committee rules in support? Not seeing anyone here in Carson or Las Vegas broadcasting. Will you open the lines, please?
Sir, the public line is open and working. There are no other callers at this time.
Thank you. Is there anyone wishing to testify in opposition? Harrison? Not seeing anyone here or in Las Vegas. Broadcasting, will you open the lines?
The public lines are open and working. There are no callers at this time.
Thank you so much. Is there anyone wishing to testify in neutral? Not seeing anyone here in Carson City or Las Vegas. Broadcasting, when you open the lines.
Chair, the public lines are open and working. There are no callers at this time.
Thank you. Then I will welcome the bill presenters back up for any final remarks, and they are waiving that ability. So with that, I will go ahead and close the hearing on, Senate Bill 17. With that, the last item we have on our agenda today is public comment. Is there anyone here in Carson City wishing to make public comment? Not seeing anyone? Is there any, there's no one in Las Vegas. Broadcasting, will you open the lines?
Chair, the public lines are open and working. There are no callers at this time.
Thank you so much. Then I will go ahead and close public comment. We have officially heard and finished our meeting today in 35 minutes, 3 bills down. So with that, as a reward, I will see you all back tomorrow at 8 a.m. This meeting is adjourned.